matter of evidence. Matter of evidence.
He has a benefit of that order till 2024.
No, my lord, 2019, my lord, is the
Till
appeal
the
filed.
disposal of the appeal.
Appeal was filed in 2020.
Till 2024.
2020, my lord, the appeal was filed in the, sorry, my lord, I'm sorry.
But disposed of in
2021.
24, Mr.
2021 appeal was filed, my lord.
Hmm.
From then, my lord, till now, my lord, they do not have a.
No, from 2020, 15th February 2020,
Please.
till the disposal of the appeal in 2024, that the injunction order granted by the trial court is in operation.
Lord, that part will not have to make a submission because the interim order was granted on that. We will have to verify, my lord, and say. But, my lord, having said that, my lord, the first appellate court, my lord, has come to a right conclusion that, my lord, the specific observations on these facts, my lord. One is regarding, my lord, from 2013 till 2019, my lord, absolutely no, my lord, cancellation notice or any kind of action taken by
It's all
them.
merit. Injunction, temporary injunction, they have to see only in respect of the possession. Agreement of sale doesn't require handing over the possession to him. Then person who has alienated, even if you take that there is a reference in that sale deed, but person who is executed is GPA holder without any consideration, he has no right at all.
Milord, there is Milord, that's the reason Milord, I have produced annexure R2. ಅದು ಸ್ಪಷ್ಟವಾಗಿದೆ. So ಈ ಸ್ವತ್ತು ನಿಮಗೆ ಒಂದು ಇದು ಮಾಡಿದೀವಿ ಅಂತ ಸ್ಪೆಸಿಫಿಕಲಿ ಮೆನ್ಷನ್ Milord.
ಯಾರು GPA holder?
GPA holder, ಇವ್ರು ಕೊಟ್ಟಿರೋ GPA holder ಗೆ.
ಏನಂತ?
ಇಲ್ಲಿ, let me kindly see page number 11 of the
whatever they have given.
Yes.
GPA holder has no right to alienate the property unless there is a consideration.
The consideration has been entirely paid, Milord. That's my submission because literally the annexure.
Revenue, that is the material, is it not?
Well, point, Milord, is after having Milord waited for so many years, Milord, he has paid. It's not a case, Milord. But
Your sale, purchase, it all will be decided by the trial court. Now, what is that material to show that you are in the possession as on today?
Milord, there are two things, Milord. One is the sale agreement which says about the possession. Second is a sale deed executed in my favor, which Milord says the registered sale deed and the possession will deliver to the sale deed.
No, after that.
That they have sought for cancellation. No.
No, it is sale deed is in the year 2013.
19, Milord, 19.
19.
Sale agreement is 13. That to be filed, but they go ahead and file a suit and obtain an injunction order.
Yes, now that as on the date of filing the suit, it is in your name. Where is
Yes,
that artist?
yes, I
Produce that. You have the copy. That is enough for deciding that. You don't have revenue records in your
Revenue, I do not have. Otherwise, Milord, may kindly have it on Saturday, Milord. I'll produce those in the interim order also, Milord, and this one both well.
Yes, Saturday. You also produce that revenue records. Please stands in whose name?
Lord, in the similar circumstances, in same case, Lord, the division bench of this honorable court has taken a view. The sale made by a power of attorney is not a proper sale.
I'm not deciding on that. This is not, I'm deciding the
Yes.
suit on the merit.
Yes,
Now it is only for injunction. Two things. One is that you have any benefit of interim order for 4 years.
yes.
If a situation, Milord, happened rampantly, registered, Milord, and showing in the incumbent certificates,
The law is that even registered, unless there is any consideration,
and
that he has no right to alienate.
they
the
should
property.
not have gone and cancelled. If they say financial assistance for the daughter's
No.
marriage, cancellation
No,
ಮಾಡಕ್ಕೆ
if they are not taking any consideration, given a GPA only for the other purpose, why they want to cancel? Because he can't alienate.
Milord, there are, Milord, one is sale agreement and second sale agreement where amount has
Yes.
been paid.
He has misleaded you, or you have
It is
collided
Milord.
with him and purchased the property.
Not the fraud played by the Milord, the thing. Milord, what's happened, Milord? Rampantly such things are happening over. There should be some, Milord, end to this practice, Milord, what my son.
That is
And Milord,
what,
praise-
that is what they're doing by the GPA holders. Not that either the original
Yes.
owner.
Ordinary farmer.
Clipper.
Cases, purchaser, They are colliding with the GPA holders and purchasing that property. That is what's also happening there.
I will not
All
place
that
my-
GPA holders. In most of the cases, where GPA holder is the party, that's all. Last matter is
Nodi, the first defendant remain.
wife has given a GPA to that husband. Has rejected that genuineness of that sale deed. Earlier than 2 matters
Howdu,
before
howdu.
we have discussed that.
Yes, yes.
Blatant illegality.
Yes, this is between 3 family members. Yes, Saturday.
Please.
Saturday, no, Monday.
Saturday, man.
Monday.
Monday,
28th.
28th.
Please.
Yes.
Yes, pastor, what is
Told that it is on Saturday, 26th of this month, my lord.
26th?
ನಾಳೆಲ್ಲ ನಡೀತಿದೆ.
Yes, we'll have it on 28th. Lease this matter on 28th. If he has not come on that day,
Next matter, my lord. Your lordship heard the matter
My
for
lord,
some time.
I request your lordship to kindly have the preliminary hearing, my lord. Otherwise, if it
Bharat,
doesn't
28th,
reach
let
us,
us see.
preliminary.
Now that there is no preliminary hearing matters because now vacation is started now.
ಅಲ್ಲ,
Therefore,
ಇಲ್ಲಾಂದ್ರೆ
now
reach
I am
ಆಗಲ್ಲ.
reaching B groups.
ಅಲ್ಲ, B group ಅಂದ್ರೆ reach ಆಗಲ್ಲ, then.
Bharat, let us say on that day. If it is not reached, you can mention, then we can give a date.
Oh, much.
About a month back, your lordship heard this matter for some time.
What is this matter?
Lord, the plaintiff's application, Lord, plaintiff is the mother, first defendant is the daughter. The daughter, Lord, gets a gift deed executed in the name of a will, my lord. The mother wanted to execute a will. The daughter and her husband, Lord, collude and they get a.
Where is your opponent?
Ma'am, the husband, Lord, collude and they get a.
Where is your opponent?
Ma'am, the.
Yes, ready?
Yes, ready.
Yes, Monday, 28th. 28th.
28th
Yes,
itself,
sir.
Lord, trial court matter is posted.
28th.
I am on the maintenance, my lord, which is amount is given by the daughter, 1,000 rupees. One daughter gives, another daughter gives me 1,000 rupees. The order of the maintenance, my lord, passed with the trial court is under challenge before this.
No, your father. Your father.
The mother, my lord.
Mother, yes, maintenance, yes, mister.
Allala, idu maintain that the gift deed is null and void.
Yes.
Lord, I sought an
No, why you have
application.
not approached that Senior Citizen Act?
Lord, no, Lord, that we had approached, my lord, that was dismissed because the father died. He was a senior citizen, but that because of that it was disposed of. Lord, now the fact remains, Lord, that during the pendency of the suit, after I filed the suit, the first defendant illegally occupies one portion of the property, first floor of the property, and starts collecting the rents from the other portions. Lord, I am in occupation of the ground floor. This honorable court in an earlier petition, my lord, has protected my possession. Lord,
Now, what is that you are challenging?
Lord, I have sought for certain pleadings, my lord, to form basis for 2 additional prayers regarding mean profits
Objecting
and
for a
possession.
mother, you are not.
Here the case is that, my lord, writ petition
Yes.
8668 of 2023 disposed.
Yes, yes.
And rejected the application of the amendment.
Yes.
And also the other application, my lord.
It is all unfortunate,
My
mister.
lord, here in the present case, the application has been rejected by this honorable court. And
No.
very same application has been made.
No, my lord.
My lord, may kindly peruse the
Lord.
previous round litigation.
Yes.
Your lordships have seen that. Your lordships wanted to know what is the stage of the suit, my lord. The other side said, my lord, it is at the stage of cross-examination of PW1. Lord, my contention was that it is at the stage of filing plaintiff's evidence.
No, you want to implead, you want to amend what?
I wanted to amend the plaint, my lord. Annexure C is the application, my lord. Kindly turn to page
What is
39.
that you want to insert?
Lord, I wanted to add 2 additional reliefs, my lord, regarding possession, my lord, and mean profits. My lord, during the pendency of the suit, my lord, subsequent to the filing of the suit,
Why it is rejected?
Lord, on the ground that you have not made out ground why you did not when the suit was filed. Kindly see, my lord, page 60, my lord, last 2-3 lines.
Para 12.
Page para 12, my lord. It is not explained by the plaintiff as to why she did not plead and plead the proposed amendment at the time of filing of the suit. Lord, now, Lord, the case is staged at the stage of evidence. Kindly turn to my application, my lord, where I have categorically said, my lord,
How it will cost to
According to the plaintiff, she says that one first floor portion, the disposition was
ಎಷ್ಟು
made.
ಜನ ಮಕ್ಕಳು ರೀ?
ಇಬ್ರು
ಇಬ್ರು ಹೆಣ್ಮಕ್ಳೆ.
ಇಬ್ರು ಹೆಣ್ಮಕ್ಳು ಇಬ್ರಿಗೂ ಗಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇವ್ರ ಮೇಲೆ ಒಂದು 7-8 ಕೇಸ್ಗಳು ಇದೆ ಸರ್ ಪೆಂಡಿಂಗ್, ಮದರ್ ಅಂಡ್ ಡಾಟರ್ಸ್.
Why? What are the cases?
ಅಲ್ಲಿ ಇವ್ರು ಒಂದ್ಸಲ ಇವ್ರಿಗೆ ಒಂದು ದೊಡ್ಡ ಮಗಳು ಒಂದು ಗಿಫ್ಟ್ ಕೊಟ್ರು.
Interim order was violated.
ಕೊಟ್ರು.
I had to file an application under 2A.
Will it not be solved by referring to that mediation?
Lord, it failed, my lord. The other side did not agree for any of the proposals. Mother is, Lord, this honorable court in the earlier writ petition, Lord, protected the possession of the mother, not to dispossess her during the pendency of the suit.
That is there.
That is there, my lord. Now, my lord, even if I succeed in the suit, my lord, if the gifted is set aside, Lord, I am entitled for mean profits. I am entitled for possession of that portion, my lord, which is occupied by the.
Why you have given a gift deed?
Lord, it is fraudulently got executed, my lord. I wanted to execute a.
For denying that the gift deed.
Please, my lord, I have challenged, mother has challenged the gift deed.
But here the case, my lord, there are 4 floors, ground and 3 floors are there. Here the amendment, my lord, may kindly peruse the page number 41.
Already, avala bidre. What is that? Why you are denying that?
My lord, here the building is constructed by this defendant number 1.
I
And
agree.
they are a joint family. And after the execution of gift
See,
deed,
she will be there till her lifetime. After that, she will not be given to anybody else. It has to be go back to you, mister.
ಇದರಲ್ಲಿ ಇದೊಂದೇ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ ಸುಮಾರು where the prayer proposed prayer direct the first defendant to tender the under the account of rent of 57,000 per month lease advance amount which is illegally using collected
Yes,
by the tenant.
when suit for set asiding that gift deed has been challenged,
Yes, my lord.
then they are right to seek for an mean profit.
In this regard, my lord may kindly come to the previous round of petition disposal where similar relief which claimed by the plaintiff has been rejected by this honorable court.
Where is that?
Put it in notice.
I sought for depositing the rents, my lord, in court.
Indirectly,
That
that
was
is not
rejected. Court observed, my lord,
No, no,
that is a mean profits if you are entitled for relief.
that is not an application for amendment.
One application for amendment. And
Adralli
another application for the deposit of rents.
ಅದು ಬಿಡಿ ಡೆಪಾಸಿಟ್ ಆಫ್ ರೆಂಟ್ ನೀವು ಪ್ರಯರೇ ಕೇಳ್ತಿದ್ರೆ ಡೆಪಾಸಿಟ್ ಆಫ್ ರೆಂಟ್ ಹೆಂಗ್ ಕೇಳ್ತೀರಾ ಅಂದಾಗ ಅವ್ರು ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ. Now that has there any application for amendment seeking same relief has been
Same
dismissed?
relief, my lord.
Same relief illa.
Yeah, amendment sought for the admission made by the plaintiff regarding it is the self-acquired property. And they wanted to amend the same as the joint family property that has been rejected by the trial court, confirmed by
Now
the
that-
honorable court.
Now that amendment is only for the mean profit.
No.
Mean
the-
profits, my lord, and
No, my lord, the paragraph, I will read. The amendment, proposed amendment, sought paragraph number 7A.
page
application
41, my lord.
39, that is the amendment paragraph, my lord, may kindly peruse.
40?
Mean profits and possession, my lord, of the portion which is in occupation of the first defendant.
My lord, may kindly peruse the
41, my lord, is
pleadings
the-
made by the plaintiff, proposed pleadings, at page number 39, annexure C.
39.
Yes, my lord.
Yes.
The plaintiff is filed the present suit seeking the relief of declaration and cancellation of the alleged gift deed. The suit scheduled property is the house property consisting of ground and above 3 floors. The ground floor consists of 2 house, 1 BHK, and another portion is 1 hall and 1 kitchen along with attached bathroom, and the 1 BHK is using by plaintiff and another portion is given for rent by the first defendant. And all these floors have been given by rent by the first defendant, only seeking the first floor portion as a possession. This is also infructuous amendment saying that we want to amend the plaint once again, seeking the relief of second floor portion and third floor portion and another ground
You
floor
will
portion.
permit you to file a fresh application to seek
Lord,
for.
it is not necessary, my lord. The defendant number 1 is in occupation of only first floor. Lord, other portions, my lord, are in occupation of tenants whom, Lord, I had inducted.
Now that defendant number is in that possession of that only one.
Only first floor, my lord.
Yeah, they says that we are receiving the rent, means we are in possession of the property and 2012 onwards we are receiving the rent. That is what the prayer number, proposed prayer number E. They are seeking 50,000 per month lease advance amount.
No,
in the
you are
capacity
seeking a
of we
mean
are-
profit in respect of only one portion.
Lord, entire building, Lord, Lord, kindly see, my lord.
Mean profit.
No, no, my lord. Kindly see, my lord, page 41, direct the first defendant to tender the accounts. Lord, this pleading, Lord, this prayer will be incorporated in the plain and court will have to decide, Lord, when the suit is finally decided, whether I am entitled to what relief. Lord, court will decide at the fact end of the trial.
Saying that.
Yes.
No, when you have sought for an set asiding that gift deed,
Yes, my lord.
yes, rightly you have to seek for a possession.
Yes, my lord.
Because when you are given a gift deed, the possession is
Lord-
also parted. Now he is saying that you are seeking possession only part of that property.
Lord, yes, my lord, regarding other portions, my lord, I have sought for mean profits. Lord, that would cover, my lord, the entire claim, my lord, so far as
You don't want the possession of that other property.
other portions,
What will be that effect if that?
Lord, no, my lord, I am,
See, gift deed is nothing but a sale deed.
Yes,
If it is set aside,
yes.
then what will happen to that possession?
Lord, possession, my lord, only first floor, at the time when the suit, my lord, kindly see.
Without
No.
seeking for any possession?
My lord, kindly see, my lord, at the time when the suit was filed, my lord, the first defendant was in a different place, my lord, altogether. In the plaint, my lord, I have indicated, my lord, the address, that is not disputed. After the suit was filed, forcibly she occupies first floor of the property. And my lord, the other, she forces the tenants to pay the rents to her for that. That is the order passed by this honorable court in the earlier round of writ petition. This honorable court has directed the first defendant to render accounts regarding the rents received by her. Not that is not there. I am protected so far as rents are concerned.
Use any document to prove that defendant number 1 is getting monthly rent, allege that proposed amendment. You are denying that you are not getting that any rent.
Yes, my lord. That is also, my lord, may kindly.
What is that material you have produced that is received?
Not that is a matter of evidence, my lord. It is now at the stage of, my lord, plaintiff's evidence. I have to file affidavit along with documents. My lord, I will place material. My lord, once the prayer, my lord, for amendment is allowed, my lord, I will place all the material before the court.
Yes, so now this stage is not arises.
My lord, may kindly peruse the previous order, my lord, para number 6. The writ petition number 8668, which was.
Page.
Alla, illi kottiri, vastagi kottiri. Para number 6. Insofar as the impugned order passed by the trial court, partly allowing IA number 3 is concerned, it is relevant to state that the plaintiff has sought for declaration that the registered gift deed dated so-and-so is null and void, and for other reasons. It is needless to state that till the plaintiff succeeds in the suit and the gift deed is declared as null and void, the gift deed would remain subsisting and would be binding upon the plaintiff, who would be entitled to seek any relief in relation to the suitable property only in the event she succeeds in the suit. Under these circumstances, the application directing defendant number 1 to deposit the rents is highly premature, since the same would arise only upon the plaintiff obtaining the declaration to the effect that the gift deed was null and void and not at a prior point of time. Under these circumstances, the trial court clearly fell in error in directing the defendant number 1 deposit of so-and-so 6,700 pending disposal of the suit. Main para number 8 may kindly be perused, my lord. Para 8.
Kindly read para 7 also. Why do you skip para 7?
To give that mean profit, Mr. That has to be proved.
Proved, yes.
That I agree, my lord.
Here he is seeking only mean profit. If that is allowed, then you can see that he has to show that material, how you are getting
That
that.
may kindly come to the prayer again. Added
Suppose
proposed prayer, he may kindly be perused for a moment.
filing the suit itself, if he had seek that for a mean profit, can you object it? You can't object
Not
it.
have.
Only that you have to go for in a trial.
My lord,
These are all subsequent events, my lord.
the prayer E, page number 41 may kindly be perused for a moment, whether he has sought for the mean profit or the rent. Page number 41 may kindly be perused, my lord.
Yes.
Direct the first defendant to tender the account of the rent, 50,000 per month, lease advance amount which is illegally using and collecting by the tenant as per the direction of the Honorable High Court of Karnataka and order passed in WP number so-and-so, void order dated so-and-so, stated in the plaint, and the plaintiff is entitled entire rent amount as mean profit. Here, when they have sought for the account of the rent, 6,700, now they have come up with the pleading 50,000, and they have not stated what is the date of disposition. Here they are saying that 2014 suit, and according to the plaintiff, 2017, in the middle of 2017, she was disposed by the first floor person.
Yes.
If at all that is there, this application is made in the year 2024 after commencement of the evidence, and that is the finding of the trial court rejecting the application.
No, instead of he has, see, earlier this court said that after obtaining the degree, again he has to file one more suit for an
Lord,
position.
Lord, the
Amendment
earlier
provision is the proceedings.
Yes,
Monday.
So many admissions are there.
Yes. Read this matter on Monday. Yes. Pass over matter. Yes, Mr. Least. Yes. We'll have that Saturday. Let us see. Saturday, if I am not sitting in Lok Adalat, I will be there for full day.
At least
But-
on the
On the first half, my lords,
preliminary hearing.
at least in the preliminary hearing
No.
stage, my lords.
Concession cannot be given only
But
one.
what happens, my lord?
All matters who are there, everybody will seek that.
I
regroup into
understand.
that,
But only from.
Marriage will not be adjourned.
That is the problem. man. In the local,
Yes.
My lords,
If you are not there, your colleague is there.
my lords, even seniors are attending. Allah. Attending. ಅಲ್ಲ ಅಲ್ಲ ಇಲ್ಲಿ ಹೇಗೆ ಅಂದ್ರೆ my
ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ರೆ ಮತ್ ಕಷ್ಟ ಅವರಿಗೆ ಮತ್ತೆ ಇಲ್ಲಿ ಅಷ್ಟು
Allah, my lords, in fact, the senior is my father, so I'll have to be with my father. My only humble submission, my lords, in the lower honorable trial court, they've been posting a day-to-day matter, my lords, on the day-to-day basis. It may not be.
Now that court cannot do anything, then vacation is there, we'll have it after vacation. Till then, nothing will happen. Yes, Mr.
Thing is going to happen.
Yes, Mr.
Allah, let them take an undertaking, my
No,
lord.
he
That's
has
it.
said no.
Allah, ನೋಡಿ ಅದಕ್ಕೆ
ಅಲ್ಲ ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ನಾಡಿದ್ದು?
ನಾಳೆಗೆ for hearing, my lords, and also different argument.
Hearing
And different argument.
ಯಾವತ್ತಿಗೆ ಇರೋದು ಅದು?
Saturday ಇರೋದು ಸ್ವಾಮಿ.
that is on another interlocutory application.
Along with final arguments.
It will not pass.
Along with, my lords, along with.
We'll see on 28th.
ಅಲ್ಲ ನಾನು
You
ಇರಲ್ಲ
need not
ಸ್ವಾಮಿ.
be there, any other colleagues. Let us see on the 26th what will happen then. Yes. If matter again posted for any arguments, then I will see that.
It is both, my lords, hearing on IA as well as final arguments.
Now that
Even for
present
adjournment
situation, you
argues for
can
hours.
also mention before the trial court.
I'll do that, my lords, I'll do that immediately. At least my lords may post it on Saturday.
28th we'll see.
At least Saturday, my lords, at least Saturday. Please, my lords.
26th.
Please.
By the time you can see what has happened.
Yes, my lords, please. Much obliged.
Serial number 54, my lords. One matter which was passed over with regard to
77, 41, Mr.
May I request it for Monday, please, my lords?
77, 21,
Monday.
Monday, Tuesday.
Please.
77,
Serial number 54 got passed over.
54. 54 passed over.
Opposite.
Yes, Mohan Kumar. 54 passover is 29th. Yes. 67. Tuesday, 29th. 21. 21 passover right there. 21. 20 na? Yes, 20 Saturday agala, Monday, 28. Yes.
Continue tomorrow.
Huh?
Serial number 66 will continue tomorrow. No, my lord, because tomorrow.
19/6/2000.
Trial court al 19/6 ante. What is
ಅಲ್ಲ,
that?
ಅದಕ್ಕಲ್ಲ, this is
There is no
the
such
compromise was played fraud by the defendants, my lord. That is the reason I have come
The
before
family
this court.
members.
That will decide.
Right, that is the
Now
reason.
that suit is pending before the trial court.
Yes, your honor. Suit is pending before the
When
trial
is the
court.
next date?
In June, my lord.
Then what is that urgency, Mr.?
Right, because since last 4 occasions before the honorable court, my lord, which was not listed. I can tomorrow, my lord,
Immediately
continue.
after vacation.
I will
My
give
lord,
the date.
only for dragging the matter, my lord, because
am
the
the-
reason
I am
is, my lord,
dependent on the
just a minute, my lord.
At 2nd May, let's. Other, if there is anybody ask the time, give a time. Otherwise, after vacation. Yes.
Tomorrow will continue.
No, that May 2nd May.
If this honorable court only sitting there.
May sitting is there, Mr. Yes.
Please.
Court officer.
Second May ಹೇಳಿದ್ದು 66. ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ.
ಮೆನ್ಷನ್ ಮಾಡಿದೆ, ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ, ಅದಕ್ಕೇನೆ
ನೋಡ್ಬೇಕಾ?
ನೋಡ್ಬೇಕು.
Court officer, serial number 72.
ಇಲ್ಲ ಸರ್. ಇಲ್ಲ.
ಸ್ಟೇ ಇಲ್ವಾ?
74.
ಇದೆ ಇಲ್ಲ.
ಸ್ಟೇ ಇರೋದೆಲ್ಲ ಡಿವೈಡ್ ಮಾಡಿ ಇಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಕೊಡ್ಬೇಕು ನಾನು ಅರ್ಜೆಂಟ್ ಆಗಿ.
Court officer, serial number 72.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
76.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Sir, 65.
76 ಆಫ್ಟರ್ ವೆಕೇಶನ್.
65, sir.
76 after vacation.
Huh?
76.
After vacation.
76 after vacation.
Huh?
76.
After vacation.
76 ಆಫ್ಟರ್ ವೆಕೇಶನ್. ರೀಚ್ ಆಗಿಲ್ದಿರೋದೆಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ
IU extended.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂಟಿ ಇದ್ರೆ
74, sir. After 74.
ಆಫ್ಟರ್ ವೆಕೇಶನ್. 60 ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಲ್ಲ ಮಾಡ್ಬಿಡಪ್ಪ ಅಷ್ಟೇ. ಯಾರು ಇಲ್ವೋ ಇಲ್ವಲ್ಲ. ಎಲ್ಲ ಮಾಡ್ಬಿಡಪ್ಪ ಅಷ್ಟೇ. ಯಾರು ಇಲ್ವೋ ಇಲ್ವಲ್ಲ.